subject for today, I think I should probably add a little postscript to the inaugural lecture that I gave on Monday, although I confess that I had not thought I would be giving the postscript quite as soon as this. You may remember, those of you who were listening to Monday's lecture, that I made a point of telling you about the internal market bill, which they had been put before the Houses of Parliament. And I said some fairly uncharitable things about the fact that the UK government seemed to think it didn't matter at all if you broke international law. And I also told you, when I was talking about that, I also told you that fortunately the House of Lords, when they were looking at that, they said, look, you know, this is really not all right. Not just the lawyers, but actually lots of people said this is not all right. And so the part of the bill, the offending part of the bill, was withdrawn. So far, so good. I reckoned without Lord Frost, who you may recall is the gentleman who negotiated from the British side, the Trade and Cooperation Agreement, and who has now taken over as what they call in English slang the point man, the chief person responsible on the British side for doing the follow-up to Brexit. And Lord Frost has just announced that unilaterally the UK intends to extend the grace periods in Northern Ireland during which they won't really be checking stuff that is going from Great Britain across the Irish Sea into Northern Ireland. The Northern Ireland Protocol says you must check, but it was agreed between the parties that there would be a grace period of a couple of months during which you didn't have to check, after which you do have to check. And if you want to extend the grace period, actually you need to agree it between the parties, because absent such an agreement between the parties, as a matter of law, you're not entitled to a grace period. Now, Lord Frost doesn't apparently read the law in that way. He says it's perfectly all right to be pragmatic, and he has just announced that unilaterally the UK will in fact continue to behave as though there is a grace period until I think something like October. Well, this is all very interesting. I have to say that my own reaction to it, and despite my British accent, you know, it's a very simple reaction, is that this is plainly unlawful. The Commission is wondering whether to bring legal proceedings, and I can understand why they would be. But it seems to me that it is intensely stupid on almost any ground. It is unlawful as a matter of law. Given that you need trust on both sides in order to operate any agreement, it is not the kind of act which is likely to foster and encourage trust. And over and above that, let's imagine you are another country somewhere that's thinking about making a trade deal with the UK. Why would you want to sign an agreement with people who apparently cannot keep their word for more than a couple of months? I just thought I would give you that little postscript because it is fresh news. It is deeply relevant to what we were talking about. I was talking about in the inaugural lecture about the rule of law. And I fear it's probably not the last example we're going to have in the context of Brexit of questions that really, you know, do give rise to big issues under the rule of law. Right. Having said all of that, now I did warn you that we were going to continue using the same method as we did last week. And so I'm about to ask you a question or two. I am going to say, let's imagine we have a nice democracy with a court system and judges ready to hear cases. And we also have a parliament that's passing laws and we have an executive that's taking decisions. Who should be able to go in front of the courts to challenge what? Let's have some ideas from you, please. And I will take a nice clean piece of paper. You see, this is, unlike the cookery classes, it's not, here's one I baked earlier, the paper is clean. And I'm going to write down what you tell me in terms of what categories of people should be able to go to the courts and what should they be able to go to the courts about. Over to you.
And please raise your hand in order to us to be able to give you the floor. You already know Eleanor's method, so she's going to wait until she has one or several answers. It may come as a
surprise on Wednesday, but it should not be a surprise today. And this is also why I put at the top of the little handout for today with the cases, I said, I warned you, as we did last week, we shall spend some of the time interactively working out together what we think the rule of law should entail, and the rest of the time looking at stuff together. So you were warned, and even though there was a typo and it said come rather than some, you probably worked out what it meant. And I did warn you that reading some of the cases would certainly help, but I'm quoting, will be no substitute for bringing an open and curious mind along to the class. So.
Vous vous souvenez que vous pouvez aussi intervenir en français. Donc,
absolument.
C'est ça l'obstacle.
La langue ne me gêne pas. Là, si vous êtes silencieux, ça me gêne plus. Mais la langue de l'intervention, vraiment, à vous de choisir. Et je préfère un français où vous vous sentez à votre aise qu'un anglais un peu hésitant, trébuchant, parce que vous ne trouvez pas les mots.
Alors, vous voulez qu'on désigne?
Ah, c'est pas moi qui va le faire.
Ah, alors, Tania Chibangu.
I think that anyone who thinks that a legislation or a government regulation have violated his rights, have a right that is generally stem from the Constitution, may have the right to access the court in order to bring his claim before a judge.
Okay. And when you, just to be clear, when you say a regulation, you mean a general law. You don't mean a decision taken specifically about him. You mean supposing Parliament passes a law, but he thinks that that law violates his rights, he should be able to go to the court.
Yes.
Okay, thank you. Somebody else, please.
There are no wrong answers. So
no,
just
we're designing a legal system. You can't be wrong. The system doesn't exist yet, okay? So you can't be wrong about what the system says because it doesn't yet exist. We're making it together.
Bon, je fais appel, alors je sais pas, je demande à, par exemple, Eva Bodichot, une idée?
Bonjour.
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 Mais en fait, moi, je suis juste pas certaine de comprendre véritablement la question, parce que forcément, comme l'a dit Tania, tout citoyen peut, a priori, aller devant une cour pour contester une loi, une décision, un acte administratif, pour contester...
Non, mais je me permets de vous donner l'exemple de l'Union européenne. Oui. Si vous voulez dire qu'un règlement ou une directive n'est pas valable, c'est pas tout citoyen qui accède automatiquement, qui peut automatiquement introduire un recours auprès du tribunal. Au contraire, il y a des règles de recevabilité et le citoyen lambda qui regarde un règlement de pêche qui est pêcheur parmi 30 000 autres pêcheurs va avoir très, très difficile à accéder au tribunal pour contester la validité de ce règlement. Donc, ce n'est pas automatique que ce soit tout citoyen dans toutes les circonstances. C'est juste... Non, mais je vous remercie, mais c'est justement pourquoi je pose la question.
Mais je pense que justement...
Voilà,
pardon, excusez-moi.
Oui, allez-y.
J'ai dit que c'est justement peut-être là que j'avais pas bien compris la question, c'est que je pensais que la question était au sein d'une démocratie nationale, dans un État, qui est-ce qui peut aller internement, enfin à l'intérieur de l'État, devant une cour, mais évidemment devant la Cour de justice de l'Union européenne, c'est beaucoup plus compliqué vu qu'il faut prouver...
Non, ce n'est beaucoup plus compliqué. Désolé, tout système national que je connais a quand même des règles.
Et donc, peut-être si je peux reformuler en français la question...
Peut-être aussi vous reformuler un peu, Emmanuel, parce qu'il se peut que ça aiderait.
Si j'ai bien compris, donc la question qui est posée par Eleanor Sharpston, elle vous demande d'imaginer qu'on est dans une démocratie, qu'on a quelques ingrédients qui sont déjà certains, c'est-à-dire qu'on a des juges qui vont pouvoir juger de plaintes qui sont déposées devant eux, on a un parlement qui fonctionne convenablement et on a un exécutif qui prend des décisions. Et dans ce contexte-là, il reste encore à décider quel va être l'accès aux juges. Qui va avoir accès au juge et pour contester quel type d'acte. Et ça, c'est maintenant un exercice d'imagination et évidemment en référence avec ce que vous connaissez, mais pas uniquement, aussi on pourrait dire de manière utopique pour être le plus conforme au rule of law, que devrait-on souhaiter pour cette démocratie imaginaire comme accès au juge?
Je remercie Emmanuel parce que c'est évidemment reformulé en français, c'était beaucoup plus clair peut-être que moi je ne l'ai fait en l'imaginant dans un anglais un peu style Oxbridge. Mais effectivement, vous avez là, comme vient de vous dire Emmanuel, vous avez là les ingrédients. Vous avez des juges qui sont assermentés, qui peuvent siéger. Vous avez un parlement qui fonctionne. Vous avez l'exécutif qui prend des décisions. Alors, reste encore quand même à formuler quelles vont être les règles dans notre démocratie, les règles qui gèrent l'accès aux juges. Si les règles sont trop strictes, l'accès aux juges ne sera pas aussi large que souhaité, n'est-ce pas? Et ça, c'est cela. Charybdis, l'autre extrême, c'est si tout le monde peut a accès au juge tout le temps, alors à ce moment-là, les tribunaux sont débordés et rien ne fonctionne. Hein? Et chaque affaire qui est plaidée doit prendre sa place dans la queue et tout le monde va attendre 5 ans avant que l'affaire ne soit plaidée. Et quelquefois aussi, ça, c'est un déni de justice si on doit attendre 5 ans. Donc, il faut vraiment essayer d'imaginer ensemble quels sont les paramètres, pourquoi est-ce qu'on va mettre les lignes là où on va les mettre, pourquoi est-ce qu'on va limiter l'accès à tel ou tel moment, ou pourquoi, au contraire, va-t-on élargir? Et je tiens à souligner, il n'y a pas de réponse incorrecte. Hein? Ce n'est pas une interrogation quelles sont vos connaissances en matière du droit de l'Union. Et je m'excuse si ma réaction a pu être comprise dans ce sens-là. C'est pas ça, je prenais ça comme exemple, hein? Parce que c'est le droit que je connais le mieux. Mais sincèrement, il n'y a pas de réponse erronée. On veut inventer ensemble et à la lumière de ce que l'on invente, on va par la suite essayer de comprendre des règles qui sont là pour illustrer ce que fait un système que je connais, à savoir le système européen. Voilà. Alors, encore, on a dit, OK, tout le monde qui considère intérêt à agir, on va définir, s'il vous plaît, l'intervenant là, poursuivez. Comment est-ce qu'on va définir un intérêt à agir? Qu'est-ce qui donne à une personne un intérêt d'agir, à agir et à une autre personne, non, vous ne l'avez pas?
Isabella Tchaïkovska?
Oui, bonjour.
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 Donc, je ne sais pas vraiment ce qu'on pourrait regrouper sous cette notion, mais j'ai pensé donc à limiter l'accès et ne pas l'octroyer à quelqu'un qui n'a pas d'intérêt pour porter son
Voilà. Non, mais j'aime bien votre intervention, mais je vous encourage à poursuivre votre chemin, n'est-ce pas? Hein? Tout en vous remerciant d'avoir eu le courage, n'est-ce pas, d'intervenir. Hein? Mais alors, comment est-ce que pour l'individu, comment est-ce qu'on va savoir s'il a un intérêt à agir?
On regarde si l'intérêt est direct ou indirect. Est-ce que la mesure ou le droit le touche directement?
Mm-hmm. Est-ce qu'il doit être le seul à être touché comme ça ou éventuellement être membre d'un groupe, un groupe close, n'est-ce pas, un groupe limité de personnes, ou est-ce que qui que ce soit qui est lésé dans un droit, qui veut démontrer, je prends l'exemple de la pêche, n'est-ce pas? Moi, je suis pêcheur. On a sorti un nouveau règlement qui délimite la maille des filets dont je peux me servir lorsque je vais à la pêche. Est-ce que tout pêcheur qui pêche avec ses filets doit pouvoir intervenir, aller devant le tribunal? Ou est-ce le fait qu'il y a beaucoup de pêcheurs, un nombre imprécis de pêcheurs qui se servent de ces filets? Est-ce que ça joue là-dedans?
Je pense qu'il y avait Anne Ancet qui voulait intervenir et je vois sur le film que c'était lié à cette question-là. Donc, Anne Ancet, vous pouvez peut-être rebondir sur la question de Eleanor Sharpston.
Bonjour. Oui, alors je vais donner une autre réponse. Mais...
Non, mais comme vous voulez, allez-y.
On ne vous entend plus.
Alors, c'est bon?
Ah, voilà.
Oui. Là, c'est bon.
Alors, peut-être pour répondre à la première question, il faudrait que ce soit une règle qui touche personnellement le pêcheur, c'est-à-dire que la règle, elle ait des conséquences sur sa pêche et sur peut-être sa production. Et après, je voulais évoquer pour les personnes pouvant avoir accès à la justice, peut-être aussi les associations lorsqu'elles agissent dans un intérêt collectif, mais plutôt pas dans un intérêt collectif qui peut être visé par exemple par leur statut. Si c'est une association par exemple qui favorise le droit à l'environnement, il faudrait que ce soit un peu écrit dans les statuts pour pas que toutes les associations puissent intervenir sur tous les sujets.
Oui, c'est très fort, c'est très utile comme réponse. Parce qu'il y a eu effectivement, c'est pas dans la liste que je vous ai donnée là, mais il y a eu une belle affaire suédoise qui s'appelle Djurgården, où effectivement, il y avait des règles en Suède qui permettaient aux associations pour la protection de l'environnement d'intervenir de plein droit devant les tribunaux. Seulement, il fallait avoir au moins 2000 adhérents à l'association. Et dans toute la Suède à l'époque, il n'y avait que 2 associations qui remplissaient cette condition-là. Hein? Alors, s'agissant par exemple d'un problème environnementale locale, n'est-ce pas? Il se peut très bien que vous ayez une association qui a été créée par des citoyens bienveillants, n'est-ce pas? Peut-être ils sont 200, mais ils ne sont pas 2000. Et là, en Suède, ils n'avaient pas accès au tribunal pour faire valoir les éléments du droit de l'environnement. Donc, vraiment, merci pour cette contribution parce que l'idée de l'association, mais aussi les conditions qui gèrent l'association, tout ça, c'est vraiment le bienvenu.
Et alors, je vois sur le fil, sur le chatbox, Kadiatou Kardoun qui pose la question d'avoir un préjudice. Et elle s'interroge en disant lié à la violation d'une loi ou de la non-conformité d'une loi par rapport à une autre loi. Ça, c'est une idée de préjudice.
OK. Et là, mais je vais me permettre, parce que ça me permet d'introduire aussi la question de savoir quand est-ce qu'on peut intervenir. Est-ce qu'il faut attendre pour avoir été lésé, ou est-ce que lorsqu'on voit qu'on va être lésé dans ses droits, on a déjà le droit d'intervenir devant les tribunaux?
Il y a une suggestion d'Iman El Otmani qui dit de mettre en place des délais de prescription éventuels.
Ah, oui. Donc, si on ne doit pas attendre trop longtemps.
Non, c'est ça.
Voilà, très bien. Donc, vous voyez, hein, si on se met ensemble, on peut quand même trouver les éléments. Hein, il faut travailler un peu ensemble. I'm going to change back in languages because I'm going to try to draw together some of what you've been saying, because you started slowly and then you got the idea, right? I mean, you need to take every element of the story in our imaginary world. Since we're starting with a clean piece of paper and we're trying to work it out, you need to take every element and decide where you want to put the balance point. All right. So let's thinking about the when, for example. Do you want to allow people to anticipate? So if there's a directive and there are some regulations that are going to be made to put the directive into law nationally, do you have to wait until the national regulations have actually become law, or are you allowed to attack them preemptively if it's clear that you were going to be harmed by them? What you do depends on your national legal system. The English legal system is actually rather friendly on judicial review in the sense that it allows you to move very, very quickly, even perhaps anticipating when you can see that the law will come into effect in 4 days' time. On the other hand, it is very unfriendly on the other end of the scale. It was said to me you shouldn't wait too long, right? In English judicial review, that is absolutely true. You have an outside limit of 3 months, but the obligation is not actually to act within 3 months, it's to act promptly. C'est-à-dire, il faut agir vite. And you can be within 3 months, but be out of time. You know, if the court thinks that you had no reason for being as slow as 3 months, if you bring your claim the last day of the 3-month period, you will be told by the judge, go away. You could see this was going to happen. You could have acted much more quickly. You wasted time there. You wasted time there. You wasted time there. I'm not letting you in. Go away, right? It is possible, if there is a really, really exceptional good reason, it is sometimes possible to go beyond the 3 months, but you have to have a truly wonderful reason why you didn't do it in 3 months. So there you have an example of a system which is very, very flexible. But as soon as you say flexibility, the other word you might say at the same time is uncertainty, right? As soon as you're flexible like that, on the one hand, the flexibility is good, but on the other hand, it means that you're not really certain where you stand. You know that it will be dangerous to wait as long as 3 months. But what would the judge say if you went after 2 months and 10 days, for example? Well, I'm not too sure. Well, what about 2 months? So, I mean, the net result is that if you want to do judicial review, as soon as somebody tells you the problem, if you are the lawyer, you start running as though you're trying to win a 100-meter sprint, because you have no idea how much time you actually have. And you know that the judge will not be friendly if you can see places, you know, where you delayed. And that also has an impact on how well the case gets prepared, because the quicker you're trying to do it, the bigger the chance that you're going to leave something out, which if you'd taken another 4 days, you'd have thought, no, wait a minute, I need to put that in as well. I use that as an illustration, right, to show you there are some trade-offs happening here. There are trade-offs also about letting everyone in through the door or letting almost nobody in through the door. And I deliberately, I gave you in the reading, I gave you some material. I'm not going to go through each case and tell it, you know, this is what this case did, but I'm going to illustrate from there, because I think that those cases are important in showing you some of the parameters. I gave you the Van Genten-Loos case, first of all, not only because it's a very, very famous case of EU law, and I can't imagine teaching a course without mentioning Van Gent, but also because that was a big choice right at the beginning of the system as to who was going to be able to enforce rights. The Van Gent divide, if you like, was, is the EEC treaty that has just been signed just an ordinary agreement between member states? If it's an ordinary agreement between member states, then if a member state breaks it, for example, by increasing the rate of duty on urea formaldehyde, then if the Commission, who is which is the body charged with surveillance of the agreement, if the Commission doesn't like it, the Commission will bring proceedings against the member state. But nobody else will be able to do that, right? An individual won't be able to do that. And that is true of many, many international treaties. And if the court had followed the very careful, very thoughtful opinion of Advocate General Römer, who ended up going more or less like in that direction, EU law would look completely different from the way we see it. It would be unrecognizable. It would be another very important international treaty, and there would be lots and lots of cases which were commission against member state, but nothing like enough, because there would be many, many illustrations of places where perhaps a member state was breaking the law. Has a very, very broad as to whether it brings infringement proceedings. If you look at the history of EU law, most of it is not made by cases that are commissioned against someone. Most of it is made by cases that come through from the national courts that were brought by ordinary individuals. And the national court at a certain moment decided it would make use of the power that it had originally under Article 177 EEC, now under Article 267 TFEU, that it would make use of the power to make a reference to the court in Luxembourg. And that reference machine has been a most potent generator of big doctrines in EU law. And it's been a generator for the simple reason that once a case comes through from a national court, whether you like it or not, whether it's the right moment for the case or not, whether the case is what we would call in loose language a very hot potato, it's a very, very difficult, sensitive, politically explosive case, you know, for choice you wouldn't want to have to decide this. If the case comes in through the reference system, and if it satisfies some fairly basic rules on admissibility, which these are really rules in Article 94 of the Rules of Procedure. They're really rules, you know, you have to know what you're talking about. But if the case satisfies very, very basic rules, then it is admissible, and then it must be decided. The court cannot avoid answering the question. Compare and contrast that with, for example, the system in the USA with the US Supreme Court. The US Supreme Court has docket control. It controls absolutely which cases it hears and which cases it does not hear. And so if you have a very interesting case, but the court doesn't want to hear it, bad luck. Whereas under the reference procedure, if you have an interesting case and the national court would make the reference, then actually the court justice has to deal with it. Now, the problem with that is that you, the litigant, actually don't control whether the court makes a reference or not. The procedure under Article 267 is a procedure of collaboration between courts. So the decision as to whether or not there is a reference is a decision for the national judge. In one sense, that's okay, because it should be the national judge who decides whether he needs help. But there is a problem, a rule of law problem about access to a court. If it's very difficult to get in through the front door with a direct action, and if access through the side door, that is by going to the national court and the national court makes a reference, is not always available. And that is why I said to you, if you read nothing else about this aspect of the rule of law, please read the opinion of Advocate General Jacobs in UPA, in Unión de Pequeños Agricultores. Because Advocate General Jacobs wrote, I mean, and I think any Advocate General I've ever spoken with, we've all said, I would have been so proud if I'd written that opinion. He wrote a magisterial opinion, which absolutely took the problem and it kind of nailed it down to the board. And he said, look, here are our rules on direct access, and they are very restrictive. If you have a decision that's addressed to you, that's okay. But if it's a more general measure, you have to show that you are individually and directly concerned. And that's a very tight test. So the front door is narrow. And then if you look at the machinery that goes via the national court and the reference procedure, that door is not always open. And the opinion was so convincing. This is why I had the passage in my notes saying, if you're curious, look at the General Court judgment in Hegel Quere, because Advocate General Jacobs had got his opinion out on the 21st of March 2002, and it was a completely convincing opinion. You know, you read it and you thought, yep, he's right. And the General Court, the Court of First Instance, read the opinion and said, yes, of course he's right. He must be right. And so they had a case before them, Hegel Quere, and so before the court decided the appeal in UPA, the General Court followed Advocate General Jacobs because he was clearly right. And so they decided Diego Quere the way that Advocate General Jacobs was suggesting they should go. Then we get the judgment of the court in UPA. And the court got cold feet. The court said, we don't think we can do that. We understand what you're saying, but we don't think we can do that. We think there has to be treaty change. And this is another point that I'm using all of this to illustrate points for you, right? Another point that I want to illustrate is it the court or the draftsman of the laws who decides whether a case can come in? You see, Advocate General Jacobs in UPA was saying, I think you can fix this. You, the court, you can fix this. Because after all, it's your case law about direct and individual concern that is very restrictive. The words direct and individual concern are to be found in the treaty, but the interpretation of what direct and individual concern means is the court's interpretation. So, come on, court. You, in a sense, made this problem with your restrictive case law, and now it's time for you to sort it out. That is, by the way, a very common lawyer's approach to what the court can do, because it's showing that the case law is the problem, and then saying, but you, the court, can fix the case law. And the Court of Justice didn't see it that way. They saw the problem as being the wording of the treaty, which they couldn't change. And therefore, the judgment in UPA says, we see there's a problem, but actually we can't fix it. We think that the member states will have to fix it because we can't fix it. So they didn't follow Francis Jacobs. And then, of course, the General Court had, as it were, decided the wrong way in Diego Quere. And so Diego Quere was also appealed. And there's, in fact, a second opinion also of Jacobs and Diego Quere, and then Diego Quere gets reversed. Now, here is a wonderful example for you also of the power of persuasion of a good Advocate General's opinion. Advocate General Jacobs' opinion in UPA was so outstanding that it informed the discussion about the Constitution for Europe. It informed the drafting of the Constitution for Europe. And when the Constitution for Europe didn't work, it also informed the drafting of the Treaty of Lisbon, where the rules got changed. They didn't get changed in exactly the way that Francis Jacobs had envisaged, but the rules on locus standi got changed in the Treaty of Lisbon. And all of that tracks back to Francis Jacobs' opinion in UPA, because he analysed the problem. He stood back and he analysed the abstract issues rather than just looking at the words of, who said what so far. He said, let's look at the problem. This is what the problem looks like. And that's also why I play these games with you at the start of a lecture, because I want to try to encourage you to look at the problem and to analyze the problem. Because if you do that, you will be very, very good lawyers. If you don't look at the problem and you just learn the case law, you will be adequate lawyers, but you will never be outstanding lawyers. In order to be outstanding, you really have to stand back and look at the problem and see what the issues are. It's against that background that I want to refer to the Parti Écologiste Les Verts case, because if you take the exact drafting of the treaty, actually a parliamentary group like Les Verts didn't have locus standi to bring an action. But in Les Verts, the court was prepared to enlarge what was going on and say, all right, we can see here is an act that's taken by an institution that creates an adverse effect. You ought to be able to challenge it, because this is the EU law system. Now the EU law system, then the EC system, is meant to generate a proper full system of remedies. It's not meant to have holes in it, all right? Here's a nice example of the system not having holes, and it's probably a case you haven't heard of, but it's one I'm very fond of because I was working at the court as a referendaire when it came in. This is case C2/88 im Svartfeld. There are two orders in Svartfeld, and I'm going to talk about the first order. Svartfeld was about something very weird and not very good going on in the fisheries sector in the Netherlands. And there was an investigating magistrate in the Netherlands, and he wanted access to some information from the commission, some commission reports, and also there were commission fisheries inspectors, and he thought it would be good to get evidence from them. So he asked the commission, and the commission put up its hands in holy horror and said, no, we couldn't possibly allow you to have our documents. We couldn't possibly allow our inspectors to come and give evidence because there is a protocol on the privileges and immunities of the institutions of the European Economic Community. We are protected by immunity. You can't have it, right? So this was a Dutch investigating magistrate, and he was a good Dutchman. He was not the sort of man who was going to take no for an answer, particularly when no seemed to be a silly answer. And so he then wrote to the court. He didn't make a reference, please understand, he did not make a reference under Article 177. He wrote to the court and he said, hello, court, I'm another court. I'm busy investigating something which may have been causing prejudice to the European Economic Community. And the Commission is being silly about giving me information. Please order the Commission to disclose the documents and make their inspectors available. Yours sincerely, Dutch investigating magistrate. Okay, now the reason that this case has got the letters IMM after the case number is that nobody had the faintest idea how to classify it. I remember being there inside the court and we all looked at this letter and we went, what is this? It's not a reference. It's obviously not a direct action, and it's not an action for failure to act because he's not bringing a claim against the Commission for failing to act. And I mean, it's not infringement. I mean, what is it? What do we do with it? Right? So it got given a registration number, C2/88, but with IM put after it. And then we all wondered what to do next. And it was a very interesting discussion because if you were being strict about what you could find on the pages of the treaty, you could not find anything which covered this letter. I mean, it was, it was like finding it was like if supposing you went to the zoo and then suddenly a dragon flew past, and you say, I know all about these animals, they're normal animals, but what was that? Oh, look, it's gone past again. What was that? It was as though a dragon had arrived. But on the other hand, it seemed to be a useful dragon. I mean, here was a investigating magistrate who was trying to enforce EU law. And the Commission was actually getting in the way by claiming immunity. And after a lot of chewing, the full court produced an order. It's not a judgment. They produced an order ordering the Commission to disclose documents or explain why they shouldn't disclose documents. Have a look at the reasoning in Svartfeld, because it really is built, it's like a fairy castle. it is built on the principle that there must be a complete system of remedies, and actually this kind of act, we must be able to get somewhere useful with it. And when the court goes back, it's always a sign. If the court goes back to the duty of sincere cooperation, and it goes back to early cases like Van Gent, it's being creative, and that it has to be creative because it can't get there otherwise. So in that order, which coincidentally they produced on my birthday that year, in that order, they required the Commission either to disclose the material or explain why they wouldn't. And there is a second order. I didn't give you the reference, but if you look up Swartveld, you will find it. There's a second order about 6 months later, I think, from memory, about December, in which the court looks at what was said to it by the Commission, and feeling much more comfortable because this is a much more easy exercise, said, yeah, I don't think that's a good reason for not disclosing, give him the information. These cases are not very often, so I do not know why Swartveld is not cited more often. I think because it's an order and it somehow is below the radar, but it's a very interesting case, and it's worth, if you're interested in rule of law, it really is worth having a look at. I went across from there in the notes that I put together. I went across to some environmental law cases. I should probably have warned you that the two I cited are both cases in which I wrote an opinion, all right? And I put them in partly because I wanted to show you how the interface between legal systems can give problems. Under the Aarhus Convention, there is meant to be access to our environmental information. And the Aarhus Convention itself understands that there are different ways of demonstrating that you should have locus standi, because it was drafted as an international convention, and it was drafted so that it was meant to work in all the different member states and other states in which it was to operate, all right? And so they had to find, in the drafting of the Aarhus Convention, they had to find a way of accommodating the fact that there are different ways of doing locus standi. And so if you look at Article 9 of the Aarhus Convention, Article 9, para 2, tells you that each party shall, within the framework of its national legislation, ensure that members of the public concerned, and then there are the two options, either that have a sufficient interest or that maintain impairment of a right where the administrative procedural law of a party requires this as a precondition, they shall have access to a procedure before a court of law. What constitutes a sufficient interest, what constitutes an impairment of a right, shall be determined in accordance with the requirements of national law and consistently with the objective of giving the public concerned wide access to justice within the scope of this convention. So the aim is wide access. And there's two different sets of rules, but you should be construing them in order to give wide access. And then the final part of that article says, to this end, the interest of any non-governmental organization meeting the requirements of national law shall be deemed sufficient for the purpose of subparagraph A, and such organizations shall also be deemed to have rights capable of being impaired for the purposes of subparagraph B. And the draftsman put his pen away and thought, job done. There we are. I've covered the two main ways of demonstrating that you have an interest and you can get through the door of the court. So having a sufficient interest or saying you have a right that's being impaired. And these came through, by the way, in our little exercise, our little game at the start of this session. Yeah. So those two routes. And I've said that you should have wide access. And I've said that if you have a proper non-governmental organization that wants to protect the environment, we're going to deem that it has sufficient interest. We're going to deem that it has a right that's being impaired. That should be the end of the story. Dear friends, it's anything but the end of the story, as those two cases will demonstrate. In the Trianel case, the German system was locked as tight shut as an oyster. And they came to the court and they kept on telling us how wonderful the system of judicial review was if you were actually in front of the court. It was really good system. It was an excellent system. It was fantastic. And I am afraid that provoked me into putting in my opinion that it reminded me of a Ferrari with the doors locked. A Ferrari is a beautiful car, but if the doors of the car are locked, it's not much good having a Ferrari, because you're not going to go anywhere in it. If you think I'm joking, if you look up Ferrari, you'll find those opinions. All right. In the Protect Nature case, you get the same problem. If you're looking at environmental law, if you're looking at trees, all right, and law protecting trees, for example, or protecting special areas of conservation, the trees themselves are not going to walk in through the door of the court and say, they're violating my rights. So you need somebody to get in there on behalf of the tree. And if somebody's going to get in there on behalf of the tree, they may not themselves have some kind of a property right that's being damaged. They may genuinely be getting in there on behalf of the tree. And you have to accommodate that. Because if you also require that they themselves must have some substantive right that is being violated, then you're going to shut them out. But if you shut them out, then one of the most effective ways of enforcing the environmental law has just disappeared. You are then left with what the Environmental Protection Agency does, the government body does, that is, the commission does. You know, you're left with organizations, entities who are civil servants, who don't have enough resources, who have to prioritize certain projects. It's all very sad, but we just can't actually take on that case as well. If you want really to enforce the law and you want the rule of law in environmental law, you have to make it possible for the concerned citizen acting through an organization to bring a case. Now, at the other end of the scale, you could, of course, go as far as saying you can have an actio popularis and anyone can bring a case. But the Aarhus Convention didn't do that. Because if you go as far as that, then in this balancing act between too little access to the court and too much access to the court, if you open the door to actio popularis, then you may get the courts overwhelmed and you may get a number of cases which actually aren't particularly good cases, aren't very well argued, and the whole system clogs up. I'm going to stop there for a 10-minute break. Conveniently, having reached the end of the access to the court bit and not having yet moved on to the intensity of review bit. So we will start again at 10 past. Hein? On commence de nouveau. On est là juste, on est à 17h. Hein? Voilà, alors on va faire comme ça.
C'est parfait. Merci beaucoup. Ah, Cécilia Riscala. Oui, Cécilia, tu as une question?
Oui. Je ne sais pas si ça vous dérange que je vous pose une question maintenant, parce que je pourrais... Votre micro est éteint, Eleanor.
Sorry, I'd muted myself. Go ahead.
Yeah, okay. So my question was, it was related to your explanation about the restrictive accession condition, admissibility, condition to access to the Court of Justice. And it makes me think about the recent case law of the Court of Justice about Article 47 of the Charter and its implication in national legal order, saying that when there doesn't exist a effective judicial remedy in cases relating to EU law, it went it said that national judges had to create judicial remedy on the basis directly of Article 47 of the Charter, even if these remedies were not foreseen in national law. And so I wanted to have your view on this case law and the restrictive interpretation of the Court of Justice of the admissibility condition. Could we say that the Court of Justice should rely upon Article 47 of the Charter to accept some cases where the admissibility conditions are not met, and when, for example, the Plowman test is not met, and we are not with an act réglementaire, but another act. And so I wanted to have your view on that, because I found the double standard interesting, in fact, the standard that the Court of Justice applies to itself and the standard it applies to national judges.
It's not the only area in which the Court of Justice applies the double standard. And I'm going to tell you, you organised a very excellent seminar on the Charter. You ought to organise a seminar on that, and you ought to ask Koen-Lennertz to come along. And I remember that he did a big keynote speech for your Charter seminar, right? You ought to try to get him to come and explain how there isn't any problem at all with the case law of the courts. It will be very entertaining. I'll come and listen. No, seriously, I'm going to give you an answer, but it's not an adequate answer. You are right in the sense that if you take Article 47 seriously, just as if you take Article 6.1 of the ECHR seriously, there are places where you kind of stub your toe against a restrictive rule and you think, wait a minute, actually, this isn't access to justice, right? The creation of remedies is a separate but linked topic, and it keeps on turning up in EU law. It turned up most notably, it turned up in the Factor Tame 1 case. That was the interim relief Factor Tame case. In that case, the UK government had entirely deliberately altered the shipping register by means of an Act of Parliament. And it was done by Act of Parliament because in English constitutional law, it was impossible and unthinkable to ask one of Her Majesty's judges to make an injunction against the Crown itself so as to suspend the operation of an Act of Parliament. It was absolutely heretical. You would be burned at the stake as a heretic, all right? And everyone knew that it was safe. If it was an Act of Parliament, it couldn't be suspended by a judge because Parliament is sovereign and it's the Crown in Parliament. You might be upset, but it couldn't be suspended. If a minister had made a statutory instrument, that could have been suspended, but not an Act of Parliament. And then David Vaughan QC and friends brought proceedings on behalf of the Spanish fishermen. And they said, EU law, we must have a remedy. The reference came to the court in Luxembourg, again, as it happened when I was the referendaire there. So I know what the discussion was. The wording of the questions, if you look at the report for Factor Tame 1, it's a 1990 report. I forget the number. I'm not Kuhn Lennertz, right? If you look at the report for the case, you have the text of the order of the questions that were referred by the House of Lords. The answer to Factor Tame 1 was going to depend on how you rewrote the questions. It was obvious you were going to rewrite them because the questions were written in a completely English drafting style, which was incomprehensible to anyone who wasn't a member of the House of Lords. Okay, so the questions were going to get rewritten. Depending on how you rewrote the questions, you would get the answer. If you rewrote the questions to say, do we need to create a brand new remedy under EU law, which is completely revolutionary? The answer to that was probably not, because we had Reva, we had Comet, we had all these cases saying that you enforce your rights under EU law according to the national procedural system, unless subject to the principles of equivalence and effectiveness. So if you rewrote it in terms of do we need to create a new remedy, the answer was bad luck, probably no. If instead of that you rewrote the questions in a different way and you rewrote them to say, if the only thing that is getting in your way is some tiny little rule of national law, then you move that rule of national law out of the way. And by the way, we already told you that in 1978 in Siementhal. So there's nothing revolutionary about it. You just apply Siementhal and you move to the side this little rule of national law. This little rule of national law that you cannot pronounce an injunction against the Crown. A very small rule of national law, right? Not so small. And the court rewrote that way round. And so that was obviously the answer. And the size of the explosion in the UK was very similar to the size of the explosion in Italy when Siementhal was decided. Because in Siementhal, the court had said, don't worry about the fact that only the Corte Costituzionale can declare a law unlawful. You're an EU law judge. You go ahead and do it. So, I mean, Siementhal was as big a shock in terms of remedies and effective protection of rights within the Italian system as Factor Tame later was within the English system. But it's the same shock. It's the same difference, as we say in Ireland. It was the same shock, right? That you really were taking the established rules and then you were pushing them back, pushing them out of the way in order to give effective protection. And that is really what Article 47 is about. And it's also about, I mean, that's why also, if you go, I'm foreshadowing a little what I'll be talking about tomorrow and the refugee crisis and access to a court. If you look at Dublin 3 and access to a court under Article 27 of Dublin 3, if you construe that in the light of the Charter, then you should be making that access broader. If you say it was all a terrible mistake, Dublin 2 was fine, Dublin 2 you didn't really ever get in through the door of the court, and Article 27 it must have been a moment's aberration that we wrote that but we didn't really mean it, then and you forget about the Charter, then you try and keep the whole thing very tight. So, I mean, you are entirely right, but I mean, with great respect, I think we need a separate seminar on that. And I think we now need to take a break between 5:10 and 5:20 in order to give people a chance. But it was an important question and I wanted to deal with it.
Thank you.
Comment ça va? Il y a des gens qui reviennent?
En fait, les gens sont là.
Les gens sont là, alors je redémarre alors.
Voilà, donc je crois que c'est possible de redémarrer.
Non, non, c'est très bien. Right. Now, the second part of this session was labeled intensity of review. And the simple question there is, how hard should the court look when it is assessing a decision that's been taken by an executive, or it's looking at the validity of rules that have been put in place by a body that has the power to make rules? You know, is it the job of the judge to have a careful, close look, or should he be having a look that's more respectful of the other parts of government? I'd just be interested to know for a minute what your reactions are, your immediate reactions to that. If anyone feels like giving me a reaction, please. Again, there's no wrong or right answer. You're not losing points if you say something.
Alors, donc quel type de recours, quelle intensité, quel degré de contrôle le juge doit exercer sur ce qui lui est soumis et par rapport notamment aux actes de gouvernement? Oui, Julia Rebecca Coelho.
Oui, merci. I think the judge should have a close look, because also the administration, the people who are working there are just human beings, and therefore they can be wrong and can make mistakes. So you should have a real revision. And moreover, I think that, for example, an administration looks from another point of view than a judge would do. So I think for maybe the checks and balances we have in a state, it is really important that a judge is not just glancing over the regulation, but really looking closely to it.
Mm-hmm. Okay, thank you for that. Does somebody have a different view?
Une autre intervention? Oui, Isabella Tchaïkovska.
Oui, peut-être un contrôle de proportionnalité.
Oui.
Parfois, on a donc des droits qui sont accordés à certaines personnes et une mesure qui vient restreindre ces droits et voir dans quelle mesure elle est proportionnelle par rapport aux droits restreints.
Mm-hmm. Okay. Right. Well, let me get the ball rolling a bit by telling you about a couple of cases, one that happened in the UK and one that happened in the US, that happened in the middle of the Second World War. And I'm actually going I can give you the references to them afterwards if you want to follow them up, because they're not in the listing, but I think they're a good place to, they're not compulsory reading, but I think they're in a good place to start for thinking. The US case is called Fred Korematsu against the US. Mr. Korematsu was of Japanese origin, and he found himself, he was an American citizen, but he was an American citizen of Japanese descent. And he was convicted of remaining in a military area, and an exclusion order was imposed on him, which effectively meant that he although he was a citizen, he was being imprisoned by reference to his ethnic or racial status, right? And by the way, he lost in the Supreme Court in the US. The other example, the one I wanted to give to you perhaps in slightly greater detail, is a case called Liversedge and Anderson against Anderson in the UK. Mr. Liversidge was arrested during wartime in May of 1940 on the grounds that the Secretary of State had reasonable cause to believe that he was of, quotes, hostile origin or association. The minister declined to describe his grounds for ordering the arrest. He just said, I had reasonable cause to believe that Mr. Liversidge was of hostile origin or association. And he said, it's enough that I say I've got reasonable cause. You can't look further. I say I'm the minister. I say I have reasonable cause. Mr. Liversidge was a volunteer RAF officer. He had Russian relatives. He changed his name for something like Persweig, I believe. And there was some vague German business connections. But anyway, he said, look, excuse me. This is not on. I was falsely imprisoned. And he brought an action for false imprisonment. And he lost. He lost at first instance. He appealed unsuccessfully up the English court hierarchy to the House of Lords. This is, of course, a dramatic time, you must understand. We're in 1940. The building of the House of Lords it sits in had been bombed. The law lords were meeting in emergency accommodation. Did the minister have to explain how or why he had reasonable cause? He said he had reasonable cause to believe. Was that mere assertion of being satisfied enough? Of the 5 law lords, 4 supported the minister. 1 brave law lord, my hero, Lord Atkin, dissented. And he said this: reasonable cause for an action or a belief is just as much a positive fact capable of determination by a third party as is a broken ankle or a legal right. In this country, the UK, amid the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom that the judges are no respecters of persons and stand between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified in law. In other words, he would have required the minister to say a bit more about why he had reasonable cause to believe that Mr. Liversidge was somebody against whom action should be taken. Now, that's a very dramatic example. And the other examples that I've given you a couple of examples. They're not as dramatic as that. Nobody's going to get as excited about copper tubing. That's chalcol, except the people who make copper tubing, right? But there is a serious issue here about how hard you look. And different countries have different traditions. My understanding of French administrative law is that originally judicial review of administrative action tended to be relatively conservative and relatively non-interventionist. The German tradition is a bit different because their authority flows from the necessity of the rule and the reasonableness of the rule. In the common law, we were initially immensely deferential. Wednesbury unreasonableness as a test is a very, very, very hard test to succeed with, because you have to show that what the minister did was so bizarre that no minister properly directing himself in law could have arrived at that conclusion. And that's a big hurdle to climb over. But then we woke up a bit and it got a little bit more reasonable, partly thanks to the influx from EU law of proportionality, for example. And I think we need to also to bear in mind that, yes, a legislator is required to make choices, and to some extent, we need to respect the choices. But that's not the same as this is complicated, so we're not going to bother to look at it, right? If you say this is terribly complicated, for example, how we calculate dumping margins is very, very difficult and complicated, and it does my head in, so I'm not going to look at it. That is a cop-out by the court. You know, yes, the calculations are complex. That's true. They are, in some respects, rather tedious, right? But we shouldn't say it's all very difficult, and therefore we cannot examine whether the basis for making the comparison between normal value and export price was fair. Because if we say we can't even look at that, we are actually waiving doing our duty as a judge. And by doing that, we're also waiving weakening the legitimacy of the trade protection measures that the union takes. I want to quote to you, because he writes better English than I speak. I want to quote to you from something that Judge Ian Forrester, who was the British judge at the General Court until Brexit, from something that he said in Brussels on the 30th of January 2020 at the 15th GCLC Conference on Competition Law. It was a contribution called A Judicial Swan Song. And he said this: whichever tradition we may favour, let me state as loudly as I can the following. The legitimacy of the enforcement activity of the institution depends on the existence of effective, genuine, visible judicial review. That is elementary, fundamental, crucial, and its importance is incapable of being exaggerated. Without the court, the Commission's activity, no matter how skilled or well-intentioned, risks being called arbitrary, illegitimate, unjust. Apart from the fact that he writes wonderful Scottish English prose, as you may gather, which makes it a joy to quote Ian Forrester, I think that he has there encapsulated a very profound truth, because in a democracy, the public authority must sometimes lose in its own courts. We do not respect electoral or judicial systems which record success for the government 99% of the time. When we see that come through from an election in a third world country, we look at each other and we say, well, of course they rigged the election. Because of course 99% of the votes were not cast for the government, right? So it is with cases against the administration. If your court system as it is constructed, with the level of intensity of review that is being applied, results in a win rate for the government of 99%, something is wrong here. And you should look at how that review is operating, because it is not operating with the required level of intensity. Because as one of you commenting said, you need a real revision because actually the people making the decisions are human beings. Even if we do not ascribe to them some additional agenda that they should be being nasty to Japanese exporters, or they should be being tough on illegal immigrants. So the Home Office in the UK should always win a case about deporting an asylum seeker. You know, even if there's not an over political agenda to follow, intensity of review matters. Now, there's also, of course, a problem about intensity of review because the judge does not have the equipment in terms of the technical knowledge to redo the technical decision. That's where the discretion comes in. But the judge can and should look at how the rules are being applied, not just do little checks to see that the procedural time limits were respected, but actually look at how the rules are applied. Hence, with anti-dumping, an illustration of an area as I used to do a lot of work in for my sins, which must have been very many sins because it's an awful area to do work in. The basic calculation is the dumping going on depends crucially on two figures, the normal value and the export price. There are various rules as to how you calculate each of those two values and in what circumstances you use an alternative version of those two values. Depending on how you play those two values against each other, you end up with a bigger or a lesser dumping margin or no dumping margin at all. And if the court is going to do its job, it has to look at how the rules are being applied. That doesn't require it to become an expert in the market for ball bearings, but it does require the court to look at the application of the rules. I have deliberately given you some cases you can go and look at. I'm not going to try to summarize, the Microsoft case, because really and truly, you couldn't try and summarize Microsoft. I am going to say that that was an example of fairly light judicial review on the Commission. I have invited you to contrast that with the Chalkor case. I do not suggest you read either of these cases in excruciating detail. Do a skim and get the flavour of what the court is doing, how much it's prepared, the General Court in Microsoft, the Court of Justice in Chalkor, how much the court is prepared to actually look at the detail. I mean, in Chalkor, although they ended up not allowing the appeal was dismissed. And although they said we don't do heavy review, nevertheless, I would say that the court had done a fairly reasonable job of looking at the detail of what had been done and checking the arguments that were made and seeing if they were, seeing if they were made out. So there is a margin of discretion, particularly there's a margin of discretion in a technical case, but it is important if you're going to give legitimacy overall to the decision maker to apply the rule of law to what has been done. I'm going to move from competition law, which is where most people look at intensity of review. I'm going to move across to the supplementary levy on milk, known to its friends as the SLOM. And I gave in the very, very first session that we did together, so there's a discussion, or so Tuesday, I started inventing an example about the market in tomatoes. Actually, that was drawn from these cases, so I'd better tell you better what they're actually about. The story starts with Mulder and von Dietzen, or rather the story starts before that, because there have always been problems about the market in milk. It's always been awash with too much milk. And successive DG Agricultures at the Commission have had bright ideas about what to do with the market in milk. And they try one idea and then it sort of doesn't work, so then they try another idea. An idea that they had about the market in milk was that they would try to entice farmers to stop producing for a while. So there were two types of undertaking on offer. There was a conversion undertaking where you actually said, look, I'm getting out of the market, and you got some money for converting your dairy herd into something else. Alternatively, there was a non-marketing undertaking. And if you signed a non-marketing undertaking, you undertook not to produce milk for 5 years, and you were paid for not producing milk. And there was nothing in the non-marketing undertaking which said what would happen after the end of the 5-year period. I mean, you know, who knew? But for those 5 years, we'd managed to get rid of you out of the market for milk. But this, unfortunately, still didn't really deal with the problem of the amount of milk. And so the Commission had a new bright idea, and it came up with the SLOM, with the Supplementary Levy on Milk, SLOM, SLOM, always referred to as SLOM. The way the SLOM worked was a milk farmer would be given a reference quantity, an amount of milk that he was entitled to produce, which was based on his production in a reference year scaled down by a little bit. If he produced that amount of milk, that was fine, all was well. If he was rash enough to produce more milk than his reference quantity, he was made subject to a very swingeing penalty. Don't produce more than your reference quantity. Here's the problem. The reference year, member states could choose from memory, they could choose between 2 reference years. The problem was that the reference years were years when the non-marketing undertaking idea had been current. And so there were farmers who were not producing milk in the reference year because they had signed non-marketing undertakings. So, if you like, they had been encouraged by the EU institutions to leave the market temporarily, and that's just what they'd done. And they'd been paid to leave the market temporarily. But what they found when they tried to come back into the market was that they were given reference quantities of 0, which is not a whole lot of use if you want to sell milk. In fact, it's completely useless. It was as though, if I can give you a different image for it, it was as though you had caught a train from Brussels to Ostend, so you bought a return ticket. And then when you got to Ostend, as you went out at Ostend, they had torn up your return ticket. And you go, hang on a minute, that was my return ticket. And they said, bad luck, you just made a single journey, which was from Brussels to Ostend, and you don't have a return ticket anymore. Well, there were a couple of farmers, Mr. Mulder and Mr. von Dietzen, who were extremely unimpressed by this. And so they went to the National Court to challenge their 0 reference quantities, and the cases were both referred to the Court of Justice. And there we have the real question, how hard do you look at this? Do you just say, this is the Commission legislating? These weren't individual decisions by the Commission, right? This was a Commission regulation. So it's a legislative measure taken by the Commission managing the market. Commission, in fact, Commission and Council, there were interlocking regulations. This is the community institutions managing the market by regulation. How much discretion do they have as to how they manage the market? Are there any limits to their discretion? I mean, they're meant to have the economic knowledge about how they run the market in milk. Is it for the court to interfere with that? Well, they came along to the hearing, and actually the Commission got given a very bad time by Sir Gordon Slynn, for whom I was working at that moment, because he asked the Commission how many farmers are concerned by this measure, and they didn't know. And then they tried to kind of run the argument both ways, because they didn't know how many farmers were affected. And so they tried simultaneously to say, it's probably not very many farmers, so it doesn't matter. Option one. Option two, oh, it might be lots of farmers, in which case it would be very disruptive to the market if they were given reference quantities. And I was sitting there as a referendar in court, listening to this argument, and watching my boss, Sir Gordon Slynn, and I was watching him sitting there, you know, with his chin propped up on his fist, and I could see that this argument was not working. And particularly, it wasn't working because the Commission tried to have it both ways. They tried to say, we're right if it's only a few farmers because it doesn't matter, and we're right if it's lots of farmers because it will be disruptive. So either way round, we're right. And it really, really didn't work as an argument because it jarred completely against notions of what is a fair thing to do, which is part of the rule of law. Yes. Now, how we label what is a fair thing to do depends on our legal tradition. For me, coming from the English legal tradition, I immediately think of equity overriding law, because equity was originally invented to deal with situations where the law produced a very unjust result. So it dealt with situations like the situation where the wife has contributed money to the matrimonial home, but the matrimonial home is in the name of the husband, so she has no legal share in the house. You know, equity comes in there to straighten out the mess if the law is producing a really unjust result. So for me, coming from my tradition, this was a clear instance of what we call in equity the doctrine of estoppel. The Commission was estopped from saying, we don't care about these people, because the Commission itself had encouraged them to leave the market on a temporary basis and was paying them to be out of the market on the temporary basis. But the Commission had never said, when it encouraged them to leave the market, you do realise you're leaving the market for good. On the contrary, it was a temporary non-marketing undertaking. So for me, it was a stopper. For my very nice French and Belgian colleagues, it was the principle, yes.
Yeah, just probably, but we hear something.
Yeah, and I've no idea what it is.
It's kind of Can I ask everyone to check? I think it's.
I don't know if it's at my end. It's a stop now. No, it's still going. I do not know what it is. It could.
It's okay. It's okay.
Okay. So for my very nice French and Belgian colleagues, this was a question of confiance légitime. You know, confiance légitime does intervene to place limits on what the administration can do. And for them, this was a violation of confiance légitime. For my German colleague, who's now a very, very, very senior lawyer in the Commission, and at that stage was a referendar just like me, he said it's all about Vertrauensverschutz. You know, the citizen is entitled to be able to place a trust in the administration to behave correctly, and that trust must be protected. And if an administration behaves like this, I mean, absolutely not. So we were all coming at it from entirely different perspectives, legally different perspectives. We were coming from where our national legal system gave us the tools. We all had the same idea, which is, you can't do that. And Gordon Slynn had the same idea, you can't do that. He said, I remember him saying to me, I don't know if the court will follow me, Eleanor, but I don't care, we need to tell them that the Commission can't behave like this. And so he wrote, with me eagerly doing some drafting for him, right? He wrote a very fighting opinion saying, you know, you can't do this. It's a breach of legitimate expectations. And the court did follow him. To the horror of the institutions, the court made a partial annulment of the relevant bit of the regulation and told the institutions to go away and try again. So the institutions went away and tried again, and they produced a very, very limited patch, as it were. They didn't give everyone reference quantities. They did the minimum they thought they could get away with. And so, of course, it litigated again in Mulder 2. And the court in Mulder 2 said, sorry, that's not good enough. And then there was yet more litigation. I mean, you need to be somebody who gets obsessive about the market in milk to want to follow this through right to the end of, you know, every last bit of the story. But what I have already told you is, I think, enough to show you that even where you have a legislative act, you may very well reach a place where actually you should intervene. But look at the basis for the intervention. The intervention was not, we know better about how to run the market in milk. That kind of an intervention from the court would not have been a legitimate intervention. It's not the job of the court to know how to run the market in milk. What the court was doing was something very different. The court was saying there are certain rules of the game, there are certain general parameters, the way that the administration should be conducting itself vis-à-vis the administré. And those rules have to be respected. And if those rules are not respected, then we, the court, will step in. We won't tell you how to fix the problem. And the court very carefully didn't say the way to solve this problem about the slob is to go and give, you know, 36,000 tons to the Netherlands to distribute in the following way. Absolutely not. That would have been the courts going into the technical detail of how to run the market in milk, and it would have been completely illegitimate. But what the court was doing was saying the broad discretion that you have, that you are entitled to exercise, is itself enclosed by certain parameters. There are certain rules you have to respect. The rules are not entirely unconnected with the fundamental principles of EU law. If you think about those principles, legitimate expectations is obviously one of them. Another one would be non-discrimination. So you shouldn't treat people who are in the same situation differently, and you shouldn't treat people in different situations in the same way unless you have objective reasons for doing those things. And then, of course, proportionality. Thank you, whoever it was who mentioned that at an earlier stage. It may have been you, Isabella. Thank you. Proportionality, a very, very important basis for the court to step in. Not to say to the administration, what you are doing is completely unthinkable from the beginning, but rather to say, look, even if the objective is legitimate, and even if, in general terms, the means for attaining the objective looks, roughly speaking, okay, actually what you've done goes beyond what was strictly necessary, for example. I mean, there's that. Sometimes there are different bits of the proportionality test that come to the fore. On the whole, this is a very... But as far as my experience of the case law goes, it is more often the case that the court accepts the legitimacy of the aim, because that's usually a matter of policy, but then looks fairly hard at whether the means for achieving the aim was correct and whether it only did what was strictly necessary. Challenging the aim is pushing against the political choices made by the legislator. And for that reason, it's not somewhere that you probably want to go. But you can apply a proportionality test perfectly well by accepting the legitimacy of the aim and then applying the detail of the proportionality test. Now, I say that, of course, it is possible that the aim may not be a legitimate aim. And if so, if it's an aim that collides with fundamental rights that are protected by the Charter, by the ECHR, then at that stage you have to say, I'm really sorry, but actually the aim is not acceptable. So we don't go down the rest of the proportionality test because the aim itself is something which we do not accept. But I mean, those cases are much, much rarer than the cases where proportionality falls down later down the test. It's always dangerous to say, is there a question that anyone has a burning desire to ask at the end of this session? But I do ask it now, because if there's a question, I want to leave time to try to answer it. So let me see whether there is any of you have a question that you would like to put forward.
Est-ce que vous avez des questions? Une question? Maybe, if I may, I had a question, Eleanor, regarding the intensity of the review. I was wondering, what about review of member states' acts? It's not a direct review, but what about the national margin of appreciation that has appeared in some part of the jurisprudence in the case law of the court? And are there any elements we should have in mind when thinking about that kind of review, which is not straightforward because the court is interpreting EU law, but at the same time, the court is looking at national law conformity with the EU law?
I'm very grateful you asked that question, and I had been wondering whether to try to fit that in as well, and I decided I couldn't actually fit it into the space. So let me give a very skeletal and abbreviated answer to that. I think it depends partly what type of a measure we're looking at, because there is a difference between a directive and a regulation. And indeed, we know that in respect of regulations, in principle, the member state isn't meant to be implementing the regulation, it's meant to be applying it. Regulations are directly applicable. Having said that, there is, on a number of occasions, you will find additional regulations at national level which are needed in order to make a regulation, an EU regulation, actually work on the ground. But there, I think the test is very much, does what the national rule does help the regulation to work or actually hinder it? So it's a little bit binary. If it hinders it working, then it's not going to survive. In terms of directives, there's the big question: how much margin of appreciation does any directive leave to the member state? And I don't think that's a question you can answer in the abstract, because I think it depends crucially on the extent of the harmonization envisaged by that directive at that particular moment. And often you will find an area starts off with minimal harmonization, and gradually the member states get a bit bolder about putting more things together under a uniform standard. So if you look at an early directive, it may have only minimum harmonization, and then there may be an amending directive and an amending directive that moves it towards a greater level of harmonisation. And as the EU law measure moves, so the scope for difference and divergence on the member state side of the equation becomes correspondingly reduced. I suppose, reaching out swiftly for an example, I'm going to reach for Maloney, which is about the European arrest warrant. The original version of the European arrest warrant did not have very detailed rules about how the arrest warrant was meant to operate if the person was tried in absentia. Then there was an amending framework decision which introduced a new Article 4A, which did precisely put together a very careful and exhaustive set of rules governing trials in absentia and European arrest warrants, and which said that providing the following rules, are respected, then a European arrest warrant can be issued and should be respected. Mr. Maloney removed himself from Italy, where he was meant to be on trial, was tried and convicted in absentia. An arrest warrant was then issued for him in the hopes of finding him and getting him back to Italy to serve his sentence. He surfaced in Spain, and then he tried to rely on the fact that the Spanish Constitution, he did a recurso de amparo, if I remember. He tried to rely on the fact that the Spanish Constitution said that you could be surrendered, but if you've been tried in absentia, then you had to be tried again in your presence, or something fairly like that. I'm quoting from memory. And the Constitutional Court in Spain sent the reference to the Court of Justice, because it looked as though you had a direct collision between EU law and Spanish constitutional law. And of course the case went to the Grand Chamber, because that's what you do with cases that are that hot. The decision of the court in Maloney has been criticised a lot by constitutional courts. I think it can be explained, however, in the following way. The member states had agreed together exhaustively what the rules were going to be about trials in absentia and the European arrest warrant. And they had also agreed that those rules respected the Charter and the ECHR. Once you have that level of agreement, there is actually no remaining scope for national constitutional law to come back into the story and introduce a different test. So I think that for things like directives and the framework decisions, it really does turn on the amount of harmonisation. And it's also, there is a more sort of general test, if you like, which is this helping or hindering what the directive is trying to do? And that's also what lies behind the Inter-Environnement Wallonie case law, yes, that even before your deadline for implementing the directive, you're not meant to do things that are going to undermine the directive. You're not meant to be pushing in the opposite direction. So for better or worse, that is my instant answer to your truly excellent question. But I readily acknowledge that it deserves a longer and a better answer.
Thank you very much. There is Tanya Chibangu who wanted to ask a question. Tanya?
Yes, thank you. I have a question regarding access to court, because there have been a lot of complaints about the individually concerned requirement. And I was wondering if from your point of view... I've lost you. Can you hear me?
You said there have been a lot of complaints about, and then the next words I lost.
Individually concerned requirement to access to court. And I was wondering, from your point of view, if you see an evolution in how the court apprehends this requirement, maybe to broaden its definition.
I think, to give you a very brief answer, I think that the changes introduced in the Treaty of Lisbon were intended to make the situation a bit less tight, a bit less restrictive. And I think that the case law has moved in that direction, but not very far. And that maybe it needs to move further. Maybe we need another Francis Jacob to get in there and do another magisterial opinion in the successor to UPA. Sadly, I shall not have that opportunity, but maybe somebody else will go and do it. I hope so.
Thank you.
I think that there are no more questions on either on the chat box or hand raised. So, Eleanor, thank you for your excellent lecture, and to all of you, we see each other tomorrow at 10 through
On se voit demain. Tout à fait.
On se voit demain. Exactement.
Voilà. Excellente soirée à tout le monde. Merci pour vos questions et votre assistance. Merci. À demain.